Hi, everyone. Welcome. We're going to get started. Can everybody hear okay in the back? Was that your dad? Was it? Can other people hear in the back? Okay, great. Thanks, Marty. Hi, everyone. Welcome. My name is Leslie Smug, and I'm General Counsel of Gordon Brothers. And we're really honored to present to you today, together with Cooley, this wonderful panel, and I think it's going to be a very vibrant discussion. And the topic that we're going to cover is monetization of IP in bankruptcy, but we'll also cover sort of out-of-court restructuring and in a non-distressed situation altogether, talking in particular about how to generate revenue and liquidity and find value in overlooked, undervalued, untapped assets, like intangible assets. So the topics that we're going to cover, that we're hoping to cover, there's quite a bit here, are on the screen. We do have slides that you can download from the app or the ABI website. We're not intending to go through the slides. We're going to have a conversation and hope that you can look to the slides for any additional information that you need. My panelists here have said that they are also willing to stay afterwards to answer any additional questions that you have or to talk about maybe topics that we didn't get to cover or didn't get to cover in detail. And of course, there's also their contact information in the materials that ABI has provided. We are expecting this to be a lively discussion. I know that we've had lively discussions in preparation for this. So if the spirit moves you, feel free to jump in during the discussion. If you'd rather wait, we will save time at the end for Q&A. I'd like to say thank you to Barb Bereskin and Katie Esser also for helping put this together. We really appreciate all your support. So with that, I'm going to introduce briefly the panelists and then let them each tell you a little bit about why they're here today and connected to this important topic. So first, I'll start with Brad Limpert, principal of Limpert and Associates of Toronto. And he specializes in technology law, licensing, and dispute resolution. And he literally wrote the book on technology law, published by Thomson Reuters. And clients say that he is brilliant in understanding the complexities of licensing. So Brad, maybe we'll go to you first, and you can tell us a little bit about your passion for IP.
Yeah, thanks for the kind introduction, and I echo the thanks to Barbara Bereskin and all the folks at ABI who helped us put together what we hope will be a really interesting and relevant panel. And why am I interested in this? For a lot of the businesses that I deal with and organizations I deal with, they are venture capital financed, so they tend to struggle financially and go into creditors' rights proceedings a lot. And a lot of times, the primary assets they have are intellectual property.
Great. So then we'll move on to Bob Eisenbach of Cooley in San Francisco, 30 years of restructuring experience as a legal practitioner, I should add. And clients say that Bob keeps an eye on the big picture, offering expertise and good judgment and keeping a cool head. So over to you.
Thank you. Yep. So my practice is principally, bankruptcy, restructuring, insolvency related, running the gamut from in-court, large Chapter 11s to a lot of out-of-court restructurings, even wind downs and dissolutions, assignments for the benefit of creditors involved in a lot of those because, like Brad, a lot of the clients that I work with are venture-backed companies. And many of those venture-backed companies, as they grow, they start engaging in all kinds of developing innovative technology and are engaged in lots of licensing transactions. And so I'm often involved in what if they go bankrupt or what if we go bankrupt side of the question during licensing work. And then in the sort of more significant insolvency proceedings, the issue of IP, what happens to it, and what can happen to it are often front and center.
Great, thanks, Bob. And then we have Josh at the end of the table, Josh Pishenson of Sherwood Partners, and also Managing Director of their sister company, Agency IP, representing creators and owners of intellectual property. And Josh is said to be known for his clear thinking through complex paradigms. Josh, over to you.
Hello. My focus is on all intangible assets from patents, trademarks, copyrights, data, source code, across the board. Do a lot of restructuring, turnaround, wind down, out-of-court restructurings, as well as going concern businesses on the happy side of our business, Agency IP.
Great, thanks. And last but certainly not least, we're thrilled to have Arthur Damerich, who's the director of the Lemelson Center for the Study of Invention and Innovation at the Smithsonian Institution. We're told that Arthur's stories of, and we've learned this too, certainly in preparation for this, stories of interesting inventions, inventors and innovators are likely to make you head right over to the Smithsonian or book your next family trip to DC after you've heard him speak. And he bears the unique distinction of probably using the most steps in his daily work, getting from meeting to meeting, because he works in the Smithsonian Institution. So it takes a long time to get from place to place. So over to you, Arthur.
Hi, everyone. I'm delighted to be here. So yeah, I am a historian of invention, innovation, and you can't and shouldn't do that without, of course, also studying patents, intellectual property. We do have a focus on independent inventors who have had kind of a rise, fall, and new rise in American history. And I would also add, one of the bigger projects I have going is to kind of study failure. And historians rarely do so, especially technology failure, in part because it leaves few records to study. But it's an area of growing interest. So delighted to be here with you.
Very interesting. Thank you so much. And for me, Gordon Brothers has a long history of investing in and helping companies leverage iconic brands, most recently such as Nicole Miller, Laura Ashley, and French Connection UK. So I'm also thrilled to be here, and I think that this will be a very interesting discussion. So let's start it off with a little bit of history, I think. When we're tackling complex topics, it's always good, I think, to go back to first principles. And Arthur, we're grateful to have you here as a guide through that. So I'll turn to your slide. And
All right.
hand it over to you.
Sure. So, I mean, many of you are familiar, of course, with the longer history, which is bankruptcy going from kind of punitive and seen as a moral failing of the individual going bankrupt, with then punishment, literally, of the body of the debtor. So debtors' prisons and, you know, that kind of imprisonment, to seeing it as an economic failure and thus something that should be worked out in a more collaborative way. The US in the 19th century, as it did with its central bank, had kind of ups and downs with bankruptcy laws, so major laws passed and then repealed. It's a country that was kind of uncomfortable with nationalizing or centralizing financial authority for quite a bit of its history, and that was also true of bankruptcy. In terms of IP, intellectual property, it is a leading country. So in the Constitution already, a clause that refers to giving inventors and discoverers some property rights, which is then enacted in 1790 with the first US patent statute, which interestingly, the very first patentee in the US, so the first holder of the first US patent, Samuel Hopkins, has his patent on a method for potash production. Potash is an incredibly important fertilizer in colonial America, actually to this day. And he goes out on the American frontier, which is then upstate New York and western Pennsylvania, and licenses his method. So from the beginning, an inventor is taking the patent and seeking to license it to people. He doesn't go bankrupt, but he's not tremendously successful. By the late 19th century, we do have this rise of independent inventors. who sometimes fail. And so I put up here an example. This is Thomas Edison's talking doll. So Edison, we know for tremendous breakthroughs in invention, first recorded sound technology. So when he invents that, people literally are lining up to hear it. Until then, any music, any speech, anything of sound was produced live in your presence. People played music in their homes, but not through any recorded device. So, I mean, this was like a really exciting breakthrough when it happened. So he immediately, within a couple of years, sought to miniaturize the wax recording and embed it in a doll that would sing lullabies to children from the recording. And it was flawed in a couple of ways. One was you didn't have electric amplification, so it's using a resonant chamber, so that it's a big, heavy doll in order to get the sound out. The recordings themselves, I don't have one to play, but they're really frightening because the women who recorded them in the factory had to work for 10 hours a day. And again, there's no master and then duplication. Each one's recorded individually by a woman singing, meaning screeching, into a large bell that goes down into a needle that's going into the wax. So these are sold at FAO Schwartz right before Christmas, and then almost all of them are returned right after. And the company is then bankrupt. But Edison, in fact, throughout his career with his inventions, would create a new company for each. And so the Edison talking doll company is defunct, bankrupt, and gone, but the main Edison invention enterprise and his other companies continue on. So that kind of set an interesting pattern. From there, if we jump, from Edison, we get the founding of GE, we get the founding of industrial research, and science and engineering are produced now in large corporate settings. And that shifts, the IP from the individual holding it, who's either selling it, building a company, or licensing, to large corporations who just hold it and either do something with it or use it defensively. And we see that the automobile industry, for example. So when Tucker comes along and wants to start a new auto company, he has a real struggle to get IP. In other words, there's a lot of patents on different parts of automobiles that he can't access and thus makes it harder to make. But then he has a number of very amazing inventions that make up this really remarkable car. But he's undercapitalized. He does some things that are seen as potentially shady. He's selling luggage. He's selling other products before he has the car. And then the big three bring him down. There's a half-decent movie on this. The automobile itself is beautiful. But of course, post-bankruptcy, there's really not, it's all liquidated. So there's not, at that time, a better understanding, as we're going to see in this panel, of how you can monetize and use IP. And then I would just wrap up these thoughts, because we want to get to the panel discussion, and say, patents, of course, are term limited. So your valuing of a patent has this kind of endpoint after which it's genericized. So that raises some challenges in doing it. But we've also seen in recent years, in the last 3-4 decades, the re-rise of the independent inventor, the significant growth of venture capital to back small startups. And as a result, in a way, there's more intellectual property on the market than there was in that kind of 1930s through 80s period. And so we're in a very dynamic market for how to think about licensing intellectual property, also how to deal with it when people fail.
That's fascinating. I think I've proven my remark to be true. I want to run right over to the Smithsonian and look at the exhibits. A question about that. Were there people that saw what Edison was doing and very quickly tried to copy his model of creating different IP companies and adopting a licensing model?
So the time period in which Edison's most active is one of really an incredible outpouring of independent invention. A huge number of Americans get 1 or 2 patents. Most of them have no idea what to do with them. So it's this kind of remarkable period where people are coming up with mechanical devices, the early electrification period. One of the curators in the museum showed me 3 filing cabinets full of original ribbon patents that are all different electrical, like switches and devices. So, you had this concept of electrifying the house, and people are coming up with little dials, push buttons. Eventually, of course, we standardize on the flip switch, but there's just this kind of dynamic outpouring. And a lot of them don't really know. There are large companies, the rail industry, then GE and other electrical, who do pick up some of the patents. You also get situations we've seen to this day where they basically just copy the idea and aren't particularly concerned about the intellectual property. And I mean, most of you are probably very familiar with this, but of course, what do you get when you license IP? You don't get anything physical. You get the right to do this, but the patent holder in the US has the responsibility to figure out if anyone's violating, and the patent holder has to go in and prosecute that. We've had any number of independent inventors through history who get enormously frustrated. Whitney in the cotton gin, he went around the American South trying to license this to small towns would have somebody who had a gin, which is how you remove the seeds from cotton, and he tries to license his improved technique, the machine. They look at it and say, you seem to want a lot of money, and I can do this on my own. So he leaves town, they do it on their own, and then he has to go back in and try to sue him. He dies basically a very bitter, impoverished man, having won lawsuits, but unable to, in fact, collect on those claims or enforce the IP. So, you know, that corporations are better at licensing and dealing with independent inventors is a relatively recent phenomenon, I would say.
Yeah, that's fascinating. So let's shift gears a little bit and step back and talk about when we're talking about intellectual property, what are we talking about exactly? So Bob, maybe I'll look to you for some commentary.
So just at a high level, you know, what is intellectual property? And I think a short answer is it means different things to different people. And there are provisions, for example, a provision of the Bankruptcy Code that defines intellectual property that doesn't really cover all of intellectual property in the way people use it. So to be specific, it definitely includes patents, patent applications, copyrights, which, by the way, are both registered and unregistered. Almost, I would say, the vast majority of copyrights are unregistered. There's copyright protection as soon as it's, you know, fixed in some medium, some work of authorship, for example. But very few are registered. There are trademarks and trade names, and there are trade secrets. And then there are things that may or may not be intellectual property depending on the context, but data is important, and, you know, the source code underlying and the object code of software. So there's just a broad range of different kinds of IP, and it does matter what the context is as to whether there is or isn't the same level of protection, depending, again, on what kind of IP you're talking about.
So when we're talking about what's not included, Josh, maybe you can talk a little bit about some other forms of intellectual property that might be considered, you know, outside of that small basket.
Yeah, so Bob touched upon that. Some of it is software. You have IPv4, IPv6 addresses, which are used to operate our internet. You also have data. You can have ultimately know-how, trade secrets. Those are things that ultimately, if they're not protected well through inventor assignment agreements, as an example, can ultimately walk out the door and create problems for businesses or even in insolvency processes, as an example.
Can I add to that? Just it's striking through people who study history of technology and look at technology transfer. It's often thought that, okay, I'm building a factory, I want to manufacture this. If I can get the IP license, I'm up and running. And what we see time and time again is, you know, people build entire factories that fail, often in, you know, developing countries seeking lower labor costs. And they fail because they haven't transferred the know-how, so the tacit knowledge that's really fundamental. And so it's interesting, I mean, when you deal with wind downs or just, you know, sales of IP, do you try to bundle in tacit knowledge somehow?
Yeah, so oftentimes when we're doing sales of IP, especially in distressed situations, acqui-hires are often very valuable in the people that go along with it. Obviously, there's no slavery, so you have to figure out how to incentivize these inventors and make sure that they even want to go to a buyer. Not everyone wants to go to the acquiring company. And sometimes you need transition service agreements in place so that they will work to do what's required so that that buyer can exercise that IP. As was mentioned earlier, I believe Arthur said it was, you know, if you are acquiring this IP and these patents and you don't know how to leverage those patents or you don't have the data or the know-how around it, you're basically stuck with a pretty piece of paper with your, you know, your assignee name associated to it. I think a big shift from, you know, early on in the IP world is you could have a bunch of inventors working for you and you can assign yourself as the inventor when these days that would be illegal. You need to have actual involvement in the creation of that IP so that if someone does acquire it, it is something you can go after and try to repurpose in a way that's going to be leverageable.
Do you have any examples of where that hasn't happened or where someone has tried to appropriate, perhaps even unintentionally, an invention?
I can offer one, and then others may have others. So, and this actually ties to a very interesting point about this. So, you've probably heard of, you know, World Trade Organization and compulsory licensing. So there's this provision in the WTO that says, you know, in case of emergencies, so for example, medical emergencies, we saw this with COVID, countries can put through a compulsory license. So Brazil did this with efavirenz, which is an antiviral for HIV/AIDS. And they followed the exact process they should have with precision. And Merck then said, okay, you've done the compulsory license, here's the patent. Brazil was unable to manufacture the drug without bringing in additional expertise, which the pharmaceutical company, having undergone this compulsory license as opposed to a more collaborative negotiation process, wasn't particularly eager to provide. And so, you know, when you see these cases like morally, ethically, in the case of, you know, HIV/AIDS or what we've seen with COVID, you kind of do say, oh my God, why are we not making these drugs in developing countries for people in them? And yet it's actually far more complex than just doing an IP license.
Yeah, if I can add one thing to that. So one important thing to take away from this panel might be that a license to a patent isn't the same as a license to the know-how to, say, make that, make whatever is covered by the patent. And we saw this in COVID as well, where lots of countries either had through their national laws or were granted rights to, say, all the patents that cover the COVID vaccines. But interestingly, virtually none of those countries could use those because they didn't have the know-how to actually do the manufacturing. And so it's important to recognize that those are different things. And I think, you know, one of the things, you know, somebody mentioned that in this area, you have to evaluate whether something like a patent right or a trademark right is just a piece of paper that somebody's waving around, or whether it has actual value. Because in relation to intellectual property, a lot of the times what you see is not the same as what you get. In litigation, about half of patent claims are held invalid. And the other thing is that for patents, quite often you need third-party rights in order to be able to bring the patented product to market and avoid a risk of being sued by third parties. So on something like biotech inventions, the average biotech invention, even when it's covered by a patent, the owner of that patent has to go out and get licenses from anywhere from about 5 to 20 different third-party licensees in order to have something they can bring to the market and not get sued for patent infringement on.
One thing I'll add is that, you know, fundamentally a patent is the right to exclude, meaning, you know, the right to, I get to use this technology, you don't. But to enforce that, obviously, if someone is infringing on the patent, you have to sue them. You have to pursue them at least. And the sort of flip side on it is, the right to exclude kind of only goes so far because it doesn't really give you, the right to do anything with it. And that's, more to the point of how it may require a lot of other intellectual property or licenses, et cetera, in order to actually take a patent, even if you own it, to market. Take a product to market, excuse me.
And to talk a little bit about where the value resides in the patent, you have your dependent and independent claims. Your dependent claims are claiming other patents' invention to validate what your independent claims are really calling upon and covering. And so those dependent claims could very well show what assets need to be licensed in order to leverage your invention. But oftentimes people, when they're going through the patenting process, they're not doing the best job with their prior art search, and thus makes those independent claims a lot less valuable if there's prior art that's already out there, whether it's in public domain or a valid granted patent. In addition to that, aside from that is the date at which you put the flag in the ground and you file your application. That basically is going to tell people where your independent claims fall and whether or not they have priority over others or not. As we've said earlier, you find so many times where you're trying to sell patents and these claims are clearly not something that should have been granted to begin with. But even in those circumstances, that doesn't mean that the entire patent could be invalid or useless. There could be a one claim amongst three that show value and could actually provide value to perhaps the person that has prior art because it expands their sort of landscape and coverage of the IP.
And part of this as well is in, someone buying patents, they're sort of offensive and defensive purchasers. There are those who want to buy it so that nobody else can use it. There are those who want to buy it because they're afraid of getting sued, and they want to own a patent that they can use in an overall patent litigation strategy against a competitor or something like that. So sometimes it's, buying a patent literally to use the underlying technology, and often it's to put it into a patent portfolio because it fills a hole that otherwise might expose that purchaser to litigation claims.
So five uses: offensive and defensive litigation, just keeping it away from your competitor, product insertion, or building upon that IP. And to building upon the IP, jumping into whether or not the continuations of those patents are open or not, and whether you can build upon that IP. A great example is barcode technology. That technology is 40 plus years old, and they have continuously developed this IP over the past 4 decades, and have commanded a lot of value in the marketplace. I mean, every time we go somewhere to buy something, a barcode's being scanned. Now, there's been some changes with the QR codes that are coming, but if you still go into the market where they're not scanning QR codes to buy your goods. So there's a value to keeping these continuations alive, as well as a continuous development, as well as the jurisdictions in which you secure your IP. If you pass that time period, you lose that value. There's no getting that back. So, filing like PCTs and making sure a company has done that and keeping those alive, which cover multiple jurisdictions, can reduce costs a little bit, but ultimately, that's the biggest problem when we're dealing with these distress situations like out-of-court restructure, wind-downs, or bankruptcy is how do you fund these maintenance fees? And that can create a ticking time bomb in terms of how quickly you can sell, because you can bet that these buyers that are looking at these IP assets, particularly patents, are hedging their bet and determining whether or not, hey, if these go into public domain, do we still get the value we need? Or is it in our best interest to try to bid for these assets and acquire them because we want the protection around them and don't want it to go into the public domain?
If I can just chip in one other thing. Josh mentioned sort of earlier the idea of acqui-hire, that sometimes you're hiring the employees or key people along with the intellectual property. And one time that turns out to be very relevant is that quite often claims by people like authors of copyright work, including software, or inventors of patents, their rights will continue on despite any restructuring. In other words, either a licensee or somebody who acquires, say, patent rights or rights in software, rights in trade secrets, doesn't necessarily acquire those rights free and clear of the claims of those upstream inventors or creators or developers. And so you can, once again, you can get your piece of paper that says, oh, I've got a patent here and it's owned by ABC Corp. Well, maybe that's presumptively true, but that's not definitively true. And if ABC was sloppy about, say, getting assignments from its contractors or various other scenarios, it's possible that ABC either doesn't own the rights at all or only partially owns the right, and whoever acquires those rights and starts to exploit them post a restructuring may get lawsuits, valid and legitimate lawsuits, from, say, the original creator of that intellectual property.
Yeah, just because the patents might show the company as the assignee and there's these key inventors that are no longer at that company, if they have not signed inventor assignment rights, that doesn't mean that they can't continue down that technology vertical and create a problem for that acquirer.
One other quick comment, and it's really a trap for the unwary, so, this is the time when we try to scare you a little bit. No, seriously, protect you from these kinds of things. We're so used in the restructuring bankruptcy world of, well, we're going to sell the causes of action, or we're going to stick those in a litigation trust, et cetera. If it's patent infringement claims in particular, you better have the rights to the patent as well. You cannot separate the two. In other words, you can't sell the patent rights to, as part of a 363 sale and think that you're going to keep the rights to pursue claims for past or future, of course, infringement, and put those in a litigation trust. It doesn't work that way. The Federal Circuit, which hears patent-related appeals, has ruled that you basically don't have standing. You've orphaned, in effect, the infringement claims if the holder of those infringement claims doesn't also have the right to exclude, doesn't have patent rights. So don't do that. It's sort of like Ghostbusters, don't let the things cross. Here, don't let them get separated.
And then further to that is when you're dealing with infringement or potential damages, if you're selling an asset, an example like in an ABC or bankruptcy, and you're not acquiring the stock of an entity, you don't have the damages associated to that entity when the patents leave. So oftentimes, going concern businesses, we advise clients to build special purpose entities for these assets so that way that the damages carry on with the patents, and that value does not get separated, especially alongside, as Bob mentioned, with the litigation rights.
So a lot of what we're talking about can be captured in the concept of due diligence. On the one hand, I think you'll have a savvy buyer who has awareness of all of the topics, all of the issues that you're talking about, but what do you do with the one that doesn't and just wants to buy? I mean, how are you bifurcating the due diligence and the helping your client create sort of a strategic approach to monetizing the asset?
Yeah, I think it's Josh's sort of 5 uses, at least if we're talking about patents. Why do you want this? What's appealing to you? Why are you interested in making the acquisition? And how does that fit into your overall strategy? And if the client hasn't thought of it themselves that way, I think helping them think it through in that fashion is very helpful for the person acquiring IP. And then the related question is, well, where is the real value? I mean, it really goes to Arthur's point about know-how and Brad's, which is how am I going to, if I buy this, how am I going to use it? Who do I need? If I don't have the team, do I have anything? You know, in other words, particularly for technology that is still in development, you know, and that's most of the technology of, you know, the companies that are, say, venture capital backed. The venture capitalists don't want to back them anymore because it just hasn't produced the returns that they were looking for on the timeline they were looking for. So it goes into some form of insolvency proceeding. It might be a bankruptcy, it might be an ABC, might even be a dissolution. But what happens to that IP, well, is it of any value? Well, you know, maybe it is, maybe it isn't, but it won't be if the people who know how to continue the development are not part of it. Because, you know, I would think, oh, well, it's software, so, you know, somebody else, some other software engineer can just look at it and kind of figure out the next step. It doesn't work that way. Highly, highly specialized, you know, millions of lines of code, et cetera. You know, it doesn't work that way. You got to have the people who know. And if you don't have them, you don't really have anything often.
Yep. I think another thing that it's really important, to your point about what you want to look at in due diligence in this area, is licenses, and for the restructuring party and downstream parties, you know, it could be the licensor is restructuring, it could be the licensee is restructuring. And there's a lot of very specific law that exists around what the rights of both licensors and licensees of intellectual property, and that drives a tremendous amount of value, or potentially can drive a lot of value for both licensees and licensors. And I mean, maybe I'll throw it to you to first talk a little bit about the U.S. situation, and then I'll talk more about the international.
Yeah, so quickly on the licenses, when the licensor is in bankruptcy, so, you know, you're representing the licensee and the licensor is in bankruptcy, what do I have here? You know, what's going to happen? Can they reject the license? Do I lose my rights? Well, there is a section in the Bankruptcy Code, Section 365N, is in Nancy, that does give protections to the licensees of a bankrupt licensor. It only goes so far. It's basically the IP that exists as of the time of the bankruptcy, but it can be very, very helpful to the licensee because the licensee can make an election. They can, obviously, if the license is rejected, they can just say, okay, it's been breached, we'll stop using it. But if they can also make an election to retain their rights to the intellectual property. And if they do so, there's certain adjustments that are made, but principally they have to keep paying whatever royalties are called for under the license agreement. And, you know, but there's a flip side to it, which is if the owner of the IP that has licensed it to this licensee may want to sell the underlying intellectual property to someone else, well, they need to know that intellectual property that they're buying has a bunch of licenses, perhaps, that have been issued under it, and they all have 365N rights, all those licensees. So that might diminish the value, or if those are producing hefty royalties, that might be a substantial part of the value. So understanding the licenses around the IP is very important.
Yeah, and what I would just add to that is internationally, it's quite variable in how these issues are treated around licensees in bankruptcy. So Canada's situation, the Canadian law is very similar to the U.S. law. But when you go outside Canada and the U.S., the rules vary tremendously. So in some countries, as I'm sure you all know, and this applies to licenses as well, ipso facto clauses are enforceable, are valid. In some countries, licenses are thought of as personal to the parties, and so they can't be assigned in a restructuring. The flip side of that is in some countries, and Canada would be the same as this, a non-assignment clause, let's say you have a bankrupt or a licensee, our bankruptcy courts will routinely ignore non-assignment clauses. So they'll say, we'll assign that license to anybody who could make use of it, if that's the acceptable or the desired restructuring proposal. Some other things that relate to this, in some countries, preserving rights is highly dependent on having that license registered in the National Intellectual Property Registry, you know, the analog to the USPTO. So there's a number of different ways that number of different things you would have to look at if the international considerations are relevant to see whether you've got value or not, whether those licensed rights survive and in what form.
Yeah, and on the U.S. side, when the licensee is in bankruptcy, so they may have built their business around this license. The same way that when the licensor is in bankruptcy, that licensee is worried, oh, am I going to get to keep that intellectual property? Same for the licensee that's in financial distress. Are they going to be able to take it away from me? Is there a clause in there that lets them take it, number one? And number two, well, if I'm in bankruptcy and I'm doing a 363 sale, I got to get that license to the buyer. Can I get the license to the buyer? Most important provision for a licensee in financial distress is the assignment clause, because U.S. bankruptcy courts will enforce the provisions of an assignment clause. And if it says, and I'm talking about for patents, you know, trademarks, et cetera, if it says you can't assign it without the consent of the licensor, of the IP owner, then you can't assign it. And in certain circuits, you can't even assume it, because they read section 365C1 to say the license can't, if it can't be assigned, then it can't be assumed, even if all you're doing is assuming it. So the point is, you know, the impact of bankruptcy in particular is on licenses, whether it's the licensor that's in bankruptcy or the licensee in bankruptcy, has to be considered as part of the diligence. And of course, financial distress, you know, there may be a provision, an ipso facto provision, and if there's never a bankruptcy filing, the licensor might terminate the license because of provisions of an ipso facto provision in the license agreement. So you have to be very aware of what those licenses and agreements provide.
Anyone else? Nope. Okay. Well, let's talk a little bit about, from the distress company's perspective, unlocking the value of IP and how we, you know, go about doing that. We can talk about innovative ways. I think a lot of us on the panel have things to say about how we can do this, including patent pools and things of that nature. So determining value, I think, is one thing that we want to talk about, and then other ways of determining sort of what is there to be uncovered within the debtors or the company's assets. Anybody want to go first?
So I guess determining if there's value there, or running a sale process, you know, is there a need or a want, first and foremost? You know, in these distress sale processes, time's of the essence. If you come across a lot of people that want the assets opposed to need the assets, well, they probably have, especially these large corporations, they have hundreds, if not thousands, of opportunities coming in their pipeline. And trying to push them to come to the table to evaluate these opportunities is sometimes difficult. Whereas if it's a need, that's a little bit more clear, because they'll run an expedited evaluation process with you and determine, hey, is this something that we're going to get in part with? And ultimately determine if it's a next step for them to get along with the sale process or not. Yeah, I'll stop there.
Yeah, I would also say that, you know, I do come back to the team, and just want to emphasize that point, because in trying to unlock the value of IP in a distress situation, part of the problem is that if those people, if you have to do a layoff, you know, many companies will have to do a layoff, who do you want to lay off last? And certainly for a software development team, it's those engineers. Who's probably the most likely having multiple job opportunities to walk out the door? It's probably those software engineers. When might you consider some form of either retention or incentive plan to keep key employees, it's probably going to center around those software engineers. So, a lot of this can depend really on whether or not, and often there is a esprit de corps among the members of that team, and they want to stay together. They believe in what they've been working on, even if, the VCs or the financing sources don't have the same belief. And so you can sometimes do the acqui-hires. You can sometimes get those teams to transition, but it's really, really important, in the software area, also in the life sciences area, where you really need the scientists who understand what has been under development. And so unlocking that value in the IP is both finding someone who wants it, of course, but also, if there is interest, making sure that, you don't have a buyer who says, well, I'm not interested anymore because, the people have gone.
It's not so helpful if your engineers go get a new job with a potential acquirer in the midst of a sale process, obviously.
Yeah, I would think that buyers oftentimes miss that step because they're looking, employees are expensive, people are expensive. So if you're looking at retention, number one, and you're looking at incentivizing people to stay when they have other opportunities to leave, I think that's a hard proposition for someone to stomach when they're looking for a value buy. Do you find yourself in those positions of, oops, you should have considered this a little bit earlier, and sort of, what happens? Is that a difficult position to counsel someone through?
Yeah, I think probably every bankruptcy lawyer has the same reaction, which is, God, I wish they had called earlier.
Yeah.
When there was more cash on hand, more liquidity available, and that's a real problem. Sometimes a motivated buyer, either in court or out of court, will step up and be willing to make a loan to bridge to a sale because they want the IP. Mm-hmm. If you have a motivated buyer, more things can be possible. I would just take it from that perspective.
Yeah, one of the examples of an oops in an acqui-hire scenario is outside of the U.S., in many parts of the world, like Canada, like Europe, those employees, those coders, software developers that you hired probably come with a lot of rights for severance pay. So if you think about those situations where you wish you had been consulted earlier, sometimes that's when, you say, and when you acqui-hired those folks, did you make sure that you did something to limit severance? Otherwise, you could be on the hook for literally years of salary, which often changes sort of risk parameters and liabilities of acquiring parties.
Also, in these distress situations is evaluating whether or not there's any CFIUS or ITAR issues, because that adds costs ultimately to the transaction, especially if you're considering foreign buyers or citizens that are trying to acquire the IP. And those costs can get pretty high pretty quickly.
So an interesting, I think, collateral effect of this would be what happens when there is a mistake. We've talked about sort of for the buyer, what happens there, for the seller, what happens. What about these collateral effects? And Arthur, I'm looking at you, sort of what gets left behind in the aftermath?
Yeah, it's kind of interesting. I mean, there's examples where this goes awry and everyone ends up on their own and not much happens. But we actually also have some interesting examples where tech clusters grew up precisely because this wasn't well handled. And so just a couple of quick examples. San Diego's biotech cluster, in no small part, is a result of the initial founding of Hybrid Tech. It was the first kind of biotech company in the area. And, San Diego in the late 70s, early 80s, you've got UCSD, you've got Salk, you've got Scripps. So you have this biomedical kind of research institutes. Hybrid Tech gets founded. It's acquired by Eli Lilly in the mid-80s, which runs it for a decade, and then by mid-1990s, basically has run it into the ground, and doesn't quite know what to do with it. And if you're from Eli Lilly, I'll apologize to you, but they really did mishandle this. But out of that, by the late 90s, early 2000s, San Diego has this flourishing biotech community with dozens and then, almost literally hundreds of startup biotech companies. And it really can be traced to that sequence. And we've seen a somewhat similar sequence in Kalamazoo, Michigan, where Pfizer purchased Upjohn and didn't keep any of the people. They basically wanted a couple of the drugs. And Kalamazoo has seen a kind of outpouring of small startups, that a number of which are doing quite well. So we've seen kind of the seeding of tech clusters through these kind of failed, well, either through an acquisition and then let the people go, or through an acquisition that failed and then a divestiture.
Yeah, and I would just add, in Silicon Valley, going back to the sort of 50s and 60s, a lot of Silicon Valley sprung from a company called Fairchild Semiconductor, one of the very, very early semiconductor manufacturers, and a number of the key people there left, either weren't happy with the way the company was going, or wanted to, just otherwise were dissatisfied, and went off and founded, little companies like Intel. And then, of course, those grew, and that entire system developed as people would leave one company and go start new ones. And venture capital was, of course, there to back many, many of those companies, including Fairchild Semiconductor.
Yeah, just another example of that in Canada. We're in Toronto, where I'm from. We're pretty happy that in the last couple of years we've had more people hired in the technology industry than either New York or Silicon Valley. And you can trace some of that to sort of failures of Nortel Network and Research in Motion, BlackBerry. And that's not the only cause, of course, but it's certainly a critical factor.
Great, so we're actually coming up on time. I want to leave just a little bit of room for questions, but let's close out at least the panel segment with some thoughts, cautionary tales. You want to start, Brad?
Sure. Just one other thing I wanted to mention, and it is covered in the slides. There certainly are, when you think you're getting intellectual property, there are other types of rights and laws and statutory overlays you have to look at. So, one example would be in the area of data. If you think you're getting data, you need to look at all the relevant privacy laws, because your ability to monetize that data or somehow exploit it, if the data was collected internationally, or you're hoping to exploit it internationally, chances are pretty good that will be materially affected by the privacy laws that are around. So that would be my sort of key point, or a key takeaway.
Yeah, and one I would say that we didn't mention before, remember how I said, well, intellectual property can include all kinds of things, including data, trademarks. Well, trademarks in particular are not covered by Section 365N, and up until the Supreme Court's decision in Tempnology, trademark licensees often found themselves, after a trademark license was rejected by the trademark owner, having no rights at all, losing them completely, having no Section 365N to fall back on. Well, the Supreme Court did issue a very important decision in Tempnology, fundamentally saying if you have rights under the contract and it's rejected, rejection is breach, it is not termination, and it's breach by the other party, not by the licensee. And I think there may be ways in which that decision could be applied outside of the trademark area. And it's very important for anyone who's involved in a trademark license to know about Tempnology and to think about it, because there are impacts, some of which are in the slides. Those topics are covered. But I also think it might possibly apply to a data license, which isn't also covered probably by 365N, because most data is just data. It's not necessarily copyrightable. And so, might that same Tempnology decision apply to data as well as trademarks?
I guess the only thing I'd say as a historian is, intellectual property is both quite fixed over time, but does have some variation. So what we think of as a patent has some remarkable consistency going all the way back to 1790, and yet right now in Congress, there is active discussion on 101 patentability. So, you know, these rules and criteria do evolve over time, so you do really want to pay attention to, you know, where the current patent law and not consult a historian on it.
To piggyback on the data comments, you know, while you do need to follow those privacy laws and disclosures that your customers may or may not have signed, there is anonymization tools out there. Sherwood, as examples, partnered with one. And so to anonymize that data so that it can generate potential value could be the lifeline to hospitals, as an example. Patient data is not something that you can easily transfer, especially with HIPAA regulations. But if you strip a lot of the identifiers and information that, you know, ties it to the patient, that data can become valuable.
Great. Thank you all so much. Any questions from the audience, comments?
Yeah.
Go ahead.
Yeah. You know, I think, I guess I'm more familiar with the use requirements in the trademark area, sort of use in commerce. Yeah. So you know, I think you've got to use it for something in commerce, or the rights can end up being lost, basically abandoned. So I don't know that I have a great answer to the question. I think what's probably most important is why do you want the trademark, you know, in the first place? What is the purchaser going to do with it? And is there some other use that's still sort of covered within, if it's a registered trademark, you know, within the scope of the registration that you can benefit, or you can reposition it? So, you know, I think it really depends on what it's going to be used for, and why, what's the motivation behind the purchase, and that may lead to an answer.
Anyone else? Excuse me, anyone else? Oh, I didn't know we were online. Good to know. I didn't know if I could see that. Okay, great. Can you address, well, trademarks and domain names? That might be a little broad to do in 30 seconds.
I'll just comment that,
Okay.
you know, the trademark is obviously something that's filed with the USPTO. Your domains are with a registrar. If you don't have access to that registrar, that may be difficult, if not sometimes impossible, to gain access to. And so it's important to make sure that you gain access to that registrar so that you can make that transfer happen, because otherwise it's a difficult task to get through.
And on trademarks, one comment, it's actually quite similar to that, you know, make sure you don't separate patents and the right to exclude from infringement. Make sure that if you acquire a trademark, you are also acquiring the goodwill with it. Otherwise, you really haven't acquired anything.
Yeah, a couple points on that. On trademarks as well, you may have to navigate during the restructuring processes some issues around quality control. So that should be one of the issues on your list throughout restructuring and thereafter, otherwise you run the risk of invalidating the trademarks. And in terms of domain names, there are a lot of similarities between domain names and trademarks, but as Josh has said, you have to be very careful around the procedural aspects of transfer of domain names and things like that, because it's an entirely separate regime.
Yeah, further to the domain transfer part, if you are doing a wind down and you're about to sell and transfer a domain name, the last thing you want is the former company's email repository getting in the hands of a potential buyer, which could ultimately open up a whole bunch of problems. And if you do not get access to those email databases and purge that information and you transfer that domain name to an acquirer and they also use Google as their email exchange, well, they'll very quickly and easily be able to log into the system. So what we do is we purge that data. For Google, as an example, there's typically a 30-day process where that data becomes purged and then is no longer accessible. If you don't wait that 30-day period before you give that access over, you could be giving over a bunch of data that you shouldn't have.
Yeah, just another add-on to that is for some businesses, social media is very important in terms of their brand presence and their customer relationships. So sometimes you want to be looking at sort of your ability to get, you know, things like Instagram, TikTok, Facebook, what have you.
Great. Well, we're over time. Thank you all for your attention, and thank you so much to my friends and panelists for a very wonderful discussion. We did have one more question. It's a 365N question that's quite involved, but I'll pass this to you, and then maybe you can get back to Doug directly. So thank you, everyone.